Good morning, friends. Under the caption Sharing of Legal Knowledge, I would like to give a talk on a legal subject. I am B.S.Bhaskara Dev, High Court advocate, enrolled in 1979. The case is a suit for perpetual injunction, without asking for a declaration of title has been dismissed, and the plaintiff who lost the case, he has gone and appealed to the first appellate court, where also he lost the case on merits, everywhere on merits only, after full-fledged evidence and all that, after full-fledged evidence and arguments. Again, from the dismissal of the first appeal, the matter is taken to High Court by way of second appeal. The second appeal also was heard on both sides, and the case was, the second appeal was dismissed on merits, holding that upholding the judgments of the two lower fact-finding courts. What is the effect of this judgment? It is binding on the judgment of the High Court is binding on the lower courts. There cannot be any further move about this matter in the lower courts. The only option is the loser of the second appeal. He can go to the Supreme Court by filing an SLP, or he can file a review petition. Except that he has no option again to go back to the lower courts. Unless the High Court has remanded the case for reappraisal of evidence or any such thing, the High Court case is all the time binding on the lower courts, and the lower courts are not supposed to accept any other case between the same parties and on the same subject matter. That is the law. That is settled principle of law. Between the same parties and on the same subject matter of the suit, there cannot be any further litigation after the High Court has dismissed the second appeal also. Unfortunately, what is happening, such cases are being taken up when the matter is brought before the lower court by the loser of the court, by the loser of the case at the High Court level also. If such cases are accepted by the lower courts, what will happen? The genuine person will be put to unnecessary trouble to again go back to the lower court and again litigation. From there again first appeal, again second appeal. So keeping all these things in view, the lower courts should not encourage this type of unending multiplicity of litigation. That is what Order to Rule 2 CPC says, and also Section 11 CPC clearly says that no suit shall be tried like this, causing inconvenience to the defendants. Once the matter has been settled and conclusively decided against that judgment, there cannot be any further move in the lower courts. My humble submission is, this type of matters should not be entertained at the lower level. Once the High Court has finally held that the lower courts judgments are binding, judgments are confirmed. That is the point which has to be this is for clarification, and this is my humble submission to the advocates fraternity. This type of things should be discussed among ourselves and to benefit the advocates community. Okay, thank you.